will rise.
Do sit down, everybody, and welcome to the Supreme Court. So we can make a start now, and we start with the appellant side. And so, if you'd like to kick us off.
May it please your lordships, I am senior counsel for the appellants Gabrielle, Laurin. My learned junior counsel is Natalie Canning. I equally present to you my learned opponents, Ms. Laurin Clausen, representing the senior counsel for the respondents, and she's accompanied by her learned junior counsel, Amirah Choudhury. Before I make my submissions, would my lords care for a summary of the facts? Dr. Cole was the lead doctor in the neonatal care unit, I will refer to it as the NICU henceforth, of the only hospital in his region. And baby X was a premature infant under Dr. Cole's charge. He was on life support system and the only one that the NICU had. It was estimated that baby X had little chance of surviving past a few hours if removed from the life support machine. Baby Y arrived at the hospital in need of urgent and immediate care. Baby Y, being a more viable infant and needing the care urgently, was placed on the life support system on the professional authority of Dr. Cole. Baby X unfortunately passed away a few hours later, and 5 days later, baby Y equally succumbed to health complications. We stand before you today, my lordships, to appeal on behalf of Dr. Cole, who erroneously pled in the High Court under poor legal counsel on the intimations made by Justice Wilberforce. My junior counsel and I will submit our points of appeal in the hopes that you will find in favor of our client, an experienced medical practitioner who has made to make an impossible choice. I will make our first submission on the matter of Dr. Cole's lack of intent in the death of baby X, an issue that was erroneously overlooked by Justice Wilberforce. My learned junior counsel will then make our second submission on the matter of Dr. Cole's defense of necessity, a perfectly valid and legal defense that was too easily dismissed by the trial judge. I wish to begin with our submission on the matter of the charge of murder laid against Dr. Cole. With the assistance, and I use this term loosely, of his legal counsel, Dr. Cole pled guilty to the charge upon strong intimations made by Justice Wilberforce, the presiding judge. There are a number of issues with these insinuations, all of which share fundamentally flawed interpretations of the facts.
The starting point in the case of conjoined twins was that oblique intention was there, and that there was nothing that the appellants could do. Arguing the case of conjoined twins is one that brings support to your case, specifically in connection with intent. And I'm a little bit confused about how that can actually happen here.
Dr. Cole lacked any kind of intention where the death of baby X is concerned. The mental element of his supposed criminal behavior is entirely absent. Lacking the direct intention to kill baby X, Dr. Cole's actions were the result of medical thought and deliberation. The charge of murder, therefore, must include the existence of indirect or oblique intention. And without such intention, the charge of murder would necessarily fail, which is what we are submitting to you, my lords.
Thank you very much. Now, Ms. Clausen, we're going to start off on our
I will quote here from the conjoined twins case: "The doctors do not cease to owe Mary a duty of care. They must continue to furnish such treatment and nursing care as may be appropriate to ensure that she suffers the least pain and distress and retains the greatest dignity until life comes to an end." And this is exactly here where we see that Dr. Cole failed his duties. He did not continue to give baby X the support and treatment that was needed, but took active steps to take away the needed treatment, which then led to the death of baby X. And additionally, this shows that Dr. Cole was not weighing the life of each baby equally, and by choosing to take baby X off the life support and give it to baby Y instead, this indicates that the life of baby Y was put above the life of baby X. And this is why the actions of taking the life support from baby X cannot be rendered lawful. It fails in both giving the life of baby X the appropriate consideration and in keeping to give baby X the treatment and nursing care that's required by the doctor.
So in effect, you say, in order to free up a life support machine, the doctor had to make a decision to murder or not murder? baby X. That's effectively what you're putting to us.
Well, we are submitting that in this case it is established that there is the attention to murder and there's the actions to constitute murder, and we will submit later on that there is no defence for this murder in this instance, but that there is that it constitutes murder.
I will now address our second ground of appeal on the valid defence of necessity arising from the difficult dilemma Dr. Cole was faced with and the qualifications he had to make this decision. In the case at hand, we submit that Dr. Cole had acted in good faith as well. His intention was to save baby Y. Furthermore, when helping baby Y, Dr. Cole meant to keep baby X alive, as it was proven that he might survive a number of hours without the life support system.
Baby Y was given life support and baby X taken off it on the basis that baby X had a small but some chance of survival, whereas baby Y had no chance of survival without the life support. Whereas is it not the case that the decision was made on the basis that baby Y had a better chance of survival on life support and that there was only a slim or small chance of survival on the part of baby X?
Rather than taking a risk and prohibit baby Y from using the life support system, just so that baby X could stay on it, he took the less viable baby.
So he withdrew the less viable of the two children.
Yes.
And his medical opinion was that the chances of that baby surviving for less than more than a few hours was slim.
Yes, but there was a chance rather than a baby Y, there was no chance that it survived. The moment this decision was made, Dr. Cole reasonably believed he was acting with the best probabilities and thus acting in good faith.
Now, Mr. Choudhury,
I'll be appealing for the second ground of appeal in saying that Dr. Cole's belief that the life support system would give baby Y a far better chance of survival than baby X was no defence to this charge. I'll be putting forward my first submission that Dr. Cole's belief was not an accurate point of view due to the lack of further medical advice other than his own, suggesting that his own level of expertise was not enough to make a sound judgment. A doctor cannot simply make the decision of taking away life support without any consultation with medical colleagues or the parents of the baby. The fact that the parents were not consulted or informed of this decision shows that Dr. Cole behaved irrationally and also unprofessionally to an extent. In the case of NHS Foundation Trust and AB 2014, which you'll find on page 103 of the bundle, it demonstrates the decision being made based on the approval of the different medics, as well as the parents having an involvement and a say in the matter. Would my lordships like a brief summary of the facts of the case?
yes, please.
A declaration was granted to an NHS trust following the extubation of a 1-year-old boy with an incurable neurodevelopment disorder, and extended respiratory support could be withdrawn. As his life expectancy was limited, his decline inevitable and imminent, the benefits of such treatment were outweighed by the burdens, and the presumption in favour of prolonging life was rebutted. The underlying medical deterioration could not be ignored in that case, and there was extensive medical examinations carried out, as well as the approval needed from the parents, as taking away respiratory support is a huge decision, and one that has to be thought about. It was also said in the case that it was not in E's best interests, as any resuscitation procedures would cause pain and distress, as well as possible injury. However, in this case, it was in baby X's interest to be kept on the life support machine, because without it, baby X would die. From the facts of the case, it does not seem that baby X was suffering. In fact, the life support machine was helping. Extensive medical research was carried out before making such a decision in that particular case, and yet Dr. Cole did not consult anyone at all.
The distinction, isn't there, between criminal issues and civil issues? And if you're wrong about something, that could give rise to a civil claim for negligence. But what are the in terms of murder, where does belief come into it?
I suppose that would come into his intentions.
Yes.
And his intentions were that baby Y would live longer. So he intended to take away baby X's life in order to give that life to baby Y. So his intention was murder, and his justification was the doctrine of necessity. But the doctrine of necessity, he does not fulfill those three requirements.
Would you like to reply?
And in an emergency situation where there isn't even time to barely consult your own colleagues, there would likely be even less time to consult the parents. For if you started discussing which parent would decide that their child would not get the life support system, we would likely be at an impasse for the longest of time. And as it stands with the facts, the way as we know them now with baby Y, who passed even 5 days after being put on the life support, there is a good chance that whichever way Dr. Cole would have decided, one baby would have likely have deceased, and the other one, there may have been a chance of survival. We may have ended up with the same outcome. But as it was, Dr. Cole was faced with a very tough decision, and he did the best he could within the medical expertise he had. And therefore, Justice Wilberforce erred far beyond his own area of expertise in making his intimations to Dr. Cole, and they included a clear lack of understanding and appreciation of all the facts and ignored the relevant parts of law, which include the importance of the intention that Dr. Cole held and the relevance of the defense of necessity in this case. And we therefore ask your lordships to find the decision unsafe. And unless I can be of any further assistance, these are my submissions.
Thank you. Well, thank you all very much for your rise and consider this. Do sit down. Now, I'm going to give our judgment on the appeal, and Stephen is then going to give our judgment on your performances in the moot. I think that's the logical way of doing it. The appellant, Dr. Cole, pleaded guilty to a charge of murder on the basis of an indication given by the trial judge as to how he proposed to direct the jury on 2 points. We've come to the conclusion that the judge's proposed direction on one of the 2 points was defective, and that since Dr. Cole pleaded guilty in reliance on the indication on that point, his conviction must be unsafe and must be quashed.
It was a close run thing, and the side that has not won today should still feel very proud of yourselves. The way we approached it was to look at 4 criteria. First of all, the skeletons and authorities that you put together, the written documentation. Secondly, to look at how you used those documents. Thirdly, your understanding and ability to expound the law, so the content, if I can put it that way. And lastly, your advocacy and your persuasion, the presentation of your cases. Balancing up the factors that we've been through. Narrowly, but nonetheless, it was felt that the appellants were the winners today of the moot, that they had just had the edge on some of those points. But one of the prizes that we had planned to give to the winners was a mini pupillage in our respective chambers. The quality was so good across the board that we want all 4 of you to come and have mini pupillages. So we hope that you will take up that offer, and certainly that you'll benefit from it.
Thank you. Thank you.